We'll call the first case, State versus McQueen.
Good morning, Your Honors. May it please the Court. My name is Mary Chartier, and I, along with co-counsel Matt Newberg, represent CA and its owners and operators, Brandon McQueen and Matthew Taylor, who are both in the courtroom here today. With the Court's permission, I'd like to request 3 minutes for rebuttal. Thank you. Our request for relief this morning is straightforward. We're asking this Court to hold that medical marijuana sales between registered qualifying patients fall within the protections of the Michigan Medical Marijuana Act. As this is the only outcome that's grounded in the language of both the MMA and the Public Health Code, we respectfully request that this Court reverse the Court of Appeals. Because I can imagine that our request for relief may certainly generate some questions from the bench, I'm happy to waive my free fire zone if anyone has any immediate questions. If the Court has no immediate questions, I'd like to start with a premise that I believe that we all can agree on, and that is, unless conduct is prohibited by law, it is not unlawful. So the Public Health Code is our framework in this case.
All right, well, you waived your time.
Yes, sir.
That's dangerous.
And that's fine.
You did so
Let's say I have a prescription for any medication. We'll pick one, Vicodin. And my friend's got a prescription for Vicodin. Can I just purchase my friend's Vicodin?
No, sir.
Why should things be different under this act than the scenario I described to you?
Because the Medical Marijuana Act has protections for the medical use. In 4A, a registered qualifying patient is immune from arrest, prosecution, or penalty for engaging in the medical use of marijuana. In 3E, the definition of medical use includes transfer, delivery, acquisition, possession. There are actually 9 specific...
Just a moment. He's not transferring his Vicodin, he's selling it.
Yes. But there's nothing as it relates to marijuana in the Public Health Code that prohibits the sale of marijuana. What the Public Health Code prohibits is the delivery, manufacture, use, or possession of marijuana. Those would be the activities that are relevant here today. So if we had prohibited conduct from the Public Health Code on one side of a chalkboard, you would not see the word sale as it relates to marijuana. You would see manufacture, again, use, possession, and delivery. If we were to take the Michigan Medical Marijuana Act and put that on the other side of the chalkboard and say what activities are immune or protected from arrest, penalty, or prosecution, you would see use, possession, delivery, or manufacture. There's no prohibition against the sale of marijuana in the Public Health Code. Thus, there did not need to be the protection articulated in the Michigan Medical Marijuana Act.
Ms. Chartier, let's just focus on the word transfer.
Yes.
Can you tell me what transfer means?
Transfer would mean one property exchange, or excuse me, taking one piece of property and exchanging that to another person.
Okay, and what does exchange mean?
Well, and if I may, transfer, the actual dictionary definition, because I may have been inarticulate, states the act of moving something from one location to another. The conveyance of right, title, or property, either real or personal, from one person to another, whether by sale, by gift, or otherwise. And that comes from the Webster's Dictionary.
Okay, so transfer does not include sale in your judgment?
No, a transfer would include sale, but
Okay.
it doesn't necessarily have to be a sale. I could transfer this pen to Mr. Newberg and not charge him any money for it. Or I could transfer this pen to Mr. Newberg and charge him money for it. The attachment of a price to a transfer is immaterial under both the Public Health Code and the Michigan Medical Marijuana Act. The attachment of a price to a transfer or delivery does not take protected conduct under the MMA and suddenly make it unlawful.
I guess I wonder whether or not you're not starting with the wrong presumption, because we know from the Act that the unlawfulness that traditionally has characterized marijuana continues to be the case, with the exception of those things that are now permitted in the new Act. And everywhere that the Act refers to the medical use of marijuana, it's usually with the additional description that it's the medical use of marijuana in accordance with the Act. So aren't you a little bit overstating things in terms of your description of the presumption here?
I don't believe so, Your Honor, because in accordance with the Act would be the 9 specific items described in medical use. So, for example, a patient could acquire marijuana, but cannot acquire more than 12 plants. A patient could possess marijuana, but cannot possess more than 12 plants. That's what the MMA entails when it talks about in accordance with the Act. There are specific parameters. But as it relates to transfer or delivery, the attachment of a price does not negate the protections of the Michigan Medical Marijuana Act. And it is an interesting dichotomy, because unless an individual is a registered qualifying patient, the recreational transfer or the recreational delivery is still punishable by the Public Health Code. But the Section 4 protections for registered qualifying patients are what is found in the Michigan Medical Marijuana Act, and they do carry out the intent of the voters. And that's so that patients have access to medical marijuana. If this court were to also look at other aspects of the Public Health Code, it would see that the Public Health Code does talk about and prohibit sales of other products. So I cannot sell pseudoepinephrine. I cannot sell drug paraphernalia. There are other aspects in the Public Health Code where the legislature used the word sale. This court cannot read sale into the Michigan Medical Marijuana Act or the Public Health Code and be congruent with its past opinions, where it states that it will not read language into the legislature's, will not read language into a statute.
Ms. Shardy, is the inclusion or the absence of the word sale, or even a broader, narrower definition of transfer, really what's critical here? I mean, it seems to me that when we're looking at the language of the rebuttable presumption, as well as other provisions, they tend to refer to the qualifying patient. For example, the rebuttable presumption says, the presumption may be rebutted by evidence that conduct relating to marijuana was not for the purpose of alleviating the qualifying patient's debilitating medical condition. Given these persistent references in the statute to the qualifying patient, doesn't it seem to limit the authority of the caregiver?
To the patient.
Right. And 2 points, Your Honor. No, I don't believe that it does. This would be a sale from a registered qualifying patient to another registered qualifying patient. The caregiver, if involved at all, would only be acting as an agent of the patient.
What I'm trying to focus on is the same thing that Justice Markman is. Everywhere that there is license to possess medical marijuana, it's to the patient who's qualified to do so, or the caregiver who the statute requires to have a direct relationship with a qualified patient. The caregiver isn't permitted under the statute to have more than the authorized number of qualified patients, right? Is correct?
Correct.
All right. So how then does a patient who is not a caregiver transfer his, under any circumstance, or sell his marijuana, or how does a caregiver sell marijuana to other than those patients that he's authorized by the statute to provide it?
To answer your last question first, the caregiver only acts at the direction of the patient. It is the patient who owns the medical marijuana. That is the patient who possesses the medical marijuana. Under the definition of medical use in 3E, it indicates all of the 9 protections, and it states to treat or alleviate a registered qualifying patient's debilitating medical condition or symptoms associated with the debilitating medical condition. The protection in 3E allows a patient to acquire, transfer, deliver, cultivate, and all of the 9 items for that patient's protection as well as another patient's protection. The caregiver patient...
So your construction is, as long as I stay within the amounts, I can be a dispensary to hundreds of people who are patients.
Because that's what the MMA allows.
Okay.
And that would be patient to patient. And the caregiver-patient model is not the only way for a patient to acquire medical marijuana under the statute. If this court looks at 4J, which is the provision that allows an individual who is a visiting qualifying patient to acquire marijuana. It provides protections for the medical use. A visiting qualifying patient would not be able to obtain a caregiver, not in any short time frame. The statute recognizes that this state might have tourists and other visitors who may engage in the medical use of marijuana, and they are protected by doing so. In order for that individual to acquire marijuana, it would be from another patient. It would not necessarily be from a caregiver selected and then registered through the Department of Licensing and Regulatory Affairs.
The Medical Marijuana Act does set forth a specific type of sale that a patient is prohibited from making, and I'm referring to MCL 333.26424 (K), which provides that any registered qualifying patient who sells marijuana to someone who is not allowed to use marijuana for medical purposes under this act shall have his or her registry identification card revoked and is guilty of a felony punishable by so on. How does that fit into your argument?
4K is a penalty for a patient or a registered qualifying patient, or a registered primary caregiver who sells to someone who is not allowed to use for medicinal purposes. And that is a 2-year penalty in addition to other penalties for the distribution of marijuana. Note that the MMA states distribution of marijuana, not sale of marijuana, because there is not the sale prohibition in the Public Health Code. That indicates that a person cannot sell to someone who is not protected by Section 4. It doesn't say that a person cannot sell marijuana at all. A patient cannot sell marijuana at all. It states that the patient cannot sell to someone who is not protected by either Section 4 or Section 8 of the Act. 4K supports our position that...
But it doesn't say that they can't sell to someone who is protected by the Act.
I'm sorry, do you say it does not say that they can sell?
Can't.
Well, they can sell.
Right.
It only states that they cannot sell to someone who is not protected.
Right.
The MMA does not need to explicitly state that they can sell in Section 4K because, again, sale is not found in the Public Health Code, and there is the 4A and 3E provisions that allow immunity for transfer or delivery. The MMA didn't need to say you can sell marijuana from one patient to another because it protects the transfer of marijuana from one patient to another. It's important to note that if we're talking about patient X and patient Y, both of them are registered qualifying patients with the state of Michigan. Both of them have had a doctor's certification that they have a serious or debilitating medical condition. Both have a registry identification card from the state. Both of these individuals are entitled to immunity and protection under the Michigan Medical Marijuana Act. The issue is, can patient X sell to patient Y? They can. Patient X
Can we hire an intermediary to do so?
If they appoint a caregiver, yes, they can. But
And the caregiver can sell it to multiple patients beyond those that there's a statutory relationship between?
only at the patient's direction.
Well, how many patients can a caregiver get? I forget.
5.
5, okay. Are you suggesting the caregiver can sell marijuana, assuming it's at the behest of his patients, to more than those 5?
Only at the behest of the patient, yes,
How is that?
because it's the patient's marijuana. The patient possesses that marijuana. The patient is the one who has
But how does a patient authorize the agent, the caregiver, to exceed the number of patients he's statutorily allowed to interact with for the purpose of transferring, distributing marijuana?
the caregiver is not acting as a caregiver for anyone other than his 5 patients. He's not.
If he's not acting as a caregiver, how does the caregiver have any authority to sell marijuana other than to, or distribute it, other than to the patients he's authorized to distribute?
The authority would only come from the patient.
That's what my question
I'm
is.
sorry.
How does the patient authorize somebody who is limited by statute to the number of people he may have these legal marijuana transactions? If I have a statutory limitation, I don't know how you can, by making me your agent, authorize me to exceed the statutory limitation. I understand you might, under your theory, you can sell to as many patients who qualify as you want and as your stash will sustain, but I don't know how you can authorize me to have interactions with people whom I don't have a statutory relationship.
You did, and you took you are taking note of the distinction between essentially the direct patient-to-patient sale and then the patient-to-patient sale through a caregiver. The authority for that would be that, again, the caregiver is acting as the agent for the patient, but is not serving as the caregiver for the patient who is acquiring the marijuana. So that caregiver, for example, is not allowed to possess plants for that patient. If we have patient X and patient Y, and the caregiver is the caregiver for patient X, that caregiver is not allowed to possess any plants for patient Y. That caregiver is still limited to the 12 plants per patient maximum under the statute. That caregiver is still limited as to the amount of usable marijuana. It is the patient's choice, patient X, to transfer that marijuana to Y, and is doing that through an intermediary.
Ms. Chartier?
Yes, sir.
This court sustained, and I think gave a reasonable reading to the act in our Kalanick and King's cases, and I think that's all that we want to do here, try to give a faithful reading of what the law reasonably says, and you have to help me because I'm not following you completely. Section 4 sets up a presumption that a qualifying patient or primary caregiver is engaged in the medical use of marijuana in accordance with this act, which is the critical language, if the qualifying patient or primary caregiver is in possession of a registry card and meets other qualifications. Does not that phrase, the qualifying patient or primary caregiver, refer back to exactly the same language earlier in the sentence? Because it then goes on to say that this presumption can be rebutted by evidence that conduct relating to marijuana was not for the purpose of alleviating the qualifying patient's debilitating medical condition. Just help me understand why the proximity of those phrases within the context of two consecutive sentences are not essentially referring to the same persons.
If we go back to 4A, a qualifying patient is protected for engaging in the medical use of marijuana. The medical use of marijuana has the 9 specific items to alleviate a registered qualifying patient's debilitating medical condition, not the.
But doesn't medical use of marijuana, isn't that given some modification throughout the Act, as in this particular provision, by the language in accordance with this Act?
The only modification would be in Section 7, which lists certain prohibitions. So, for example, at a correctional facility, a person cannot engage in the medical use of marijuana and also cannot possess marijuana. That doesn't change the definition of medical use. What that does is a patient does not have the Section 4 protection, and that patient cannot assert a Section 8 protection for possession. It does not change that medical use definition. The medical use definition is consistent throughout the Michigan Medical Marijuana Act. It doesn't alter depending on the section that's being read. If this court looks to, and I want to go back and really try and answer your question, 4A references 3E, and that says a qualifying patient's medical use. That refers to a qualifying patient. If I'm an individual patient with no caregiver, transfer does not, of course, mean that I'm transferring either to or from a caregiver. It's going to mean I'm transferring either to or from another patient. It's the same with delivery. It's the same with acquisition. That patient has to acquire the marijuana from somewhere. That would be from another patient. As it relates to the rebuttable presumption, it would be the burden of the prosecutor in an individual case to state that the patient's conduct related to marijuana was not for the purpose of alleviating the qualifying patient's debilitating medical condition. That does not state medical use. It's much broader. In this situation, the patients who were members at CA were certainly engaged in conduct related to marijuana, their conduct related to marijuana was for the purpose of alleviating their medical condition. As members, they had access to other strains. So they weren't limited to only either what they were growing or what their caregiver was growing. They also had access to an uninterrupted supply. So with the individuals who testified at the hearing, they talked about the fact that some of their caregivers just couldn't grow. They went through 4 months and they couldn't get the plants to flower, and they were going through gaps where they didn't receive their medical marijuana. One gentleman had cancer and had not had anything to eat by mouth in 8 years. That individual should not have this interrupted supply of a medication that his doctor has believed would benefit him.
So just so I understand your response to Justice Markman, because in Section 4A, they refer to a qualifying patient, and in Section 3, they refer to a qualifying patient. When in Section 4, they make a rebuttable presumption that refers to the qualifying patient, they didn't really mean the, they meant a?
No, sir, they did mean the. So, for example, if patient A is engaged in the transfer of medical marijuana for a price to patient B, then if the prosecutor wanted to say patient A or patient B, those individuals were not engaging in conduct related to marijuana for the purpose of alleviating their medical conditions, they certainly could, and the burden would be on the prosecutor to do so. What I'm stating is it's not dispositive.
But how is the seller's transfer alleviating that, when he says the qualifying patient, it's the seller. How is the seller's giving of marijuana alleviating the seller's pain?
It is, and it is conduct related to marijuana, so it is not so specific as sale or transfer. But how is patient A's conduct related to marijuana alleviating that person's debilitating medical condition?
Right. When I'm giving away my medical marijuana, let's leave sale out of it, I'm giving it away to somebody else. How's that alleviating my medical need for medical marijuana?
With a model like CA, that patient would have access to other strains that may be more beneficial to them.
But this is a grammatical question, not policy question. It seems to me that 4D requires that the seller be engaged in conduct with respect to medical marijuana to alleviate his or her medical condition.
Correct.
Not somebody else's. So I don't understand how the transfer of my medical marijuana to you, even if you're a qualifying patient, alleviates my medical condition, which is the only reason I have a right under this statute to have marijuana in the first place.
There may be circumstances where a prosecutor could show that it does not, but under the CA...
Just tell me, in this very simple situation, explain to me any hypothetical where my giving you my medical marijuana alleviates my medical condition.
In the CA model, the patient who is transferring the medical marijuana has access to other strains that may be more beneficial for them. One of the patients testified at the hearing that she had tried different strains, and different strains had different effects. One would make her would enable her to sleep at night. Another would help with her appetite. So if I am transferring under the CA model, I have access to other strains that may be more beneficial to me. Or
So your test requires that something other than a commercial exchange has to be established for each of these transfers. Isn't that right?
I'm sorry, I didn't understand the question. I'm sorry.
In order for you to square the circle here, you've said each exchange where one patient is transferring to another must benefit the transferor, not the transferee, right? So each exchange, you said, well, one of the reasons is you can get a better strain. So each exchange must be justified by a benefit to the transferor, the seller. Each one, right?
Under 4D, under the rebuttable presumption.
You know, if it doesn't directly benefit me, alleviate my pain or medical condition, I can't transfer it to somebody else.
I respectfully would disagree with the direct benefit. I don't see that language in the statute.
Well, alleviating the qualifying patient's debilitating condition or symptoms. It has to do that, or it's not a legal transfer.
Conduct related to the marijuana has to be for that person's alleviation of pain, yes.
So doing it because I'm a good-spirited citizen and I want to share my stash with somebody else, that's not sufficient, right? Under your theory, under your construction.
If we incorporate 4D, it would appear that the language "the" for the registered qualifying patient would support your position.
Well, more than that, it's necessary. You are conceding that medical use must treat or alleviate the debilitating medical condition of the qualified user.
That's the seller in this case.
Medical use it says for a registered qualifying patient's debilitating medical condition in 3E.
I understand that, but because 4D imports, if you will, medical use, it must be the debilitating medical condition.
Yes, but again, I would point out that that would be the burden for the prosecutor to show that.
But a minute. Unless you are encouraging people to engage in conduct not authorized by the statute,
No.
Your construction means that I can't transfer my medical marijuana to anybody else unless that inures to my benefit.
Correct.
And not just a general benefit, it reduces my symptoms or condition.
If there's an alleviation, yes.
Right. So it's not because I can commercially benefit, it's not because my feeling of generosity is satisfied, it's because I get some alleviation of my symptoms.
The commercial benefit may assist the patient. That may assist the patient in the ability to, again, purchase other strains, to engage in the medical use. So the language specific conduct related to marijuana is very broad.
Ms. Chartier?
Yes, sir.
Section 4E of the Act, and I really do think this court best protects individual liberty when we interpret the law faithfully and let the legislative branches do their own work. But Section 4E specifically provides that compensation of a primary caregiver for costs associated with assisting a qualified patient with medical use, quote, shall not constitute the sale of controlled substances. You know that provision?
Yes, sir.
Now, why would this provision even be necessary if sales were otherwise permitted under the Act? What would be the point of exempting something from the scope of a sale if everything else was okay?
4E takes the exchange of personal property, which most individuals would recognize would be a sale, and exempts it from sales tax, possibly zoning issues if a municipality were to want to zone certain businesses in other places. 4E does not mean that the medical marijuana or a medical marijuana sale is prohibited by the MMA. 4E only states that the compensation that a caregiver receives.
Well, when you say that something A, B, and C don't constitute a sale, you're saying it for some purpose. It's not just an offhanded comment by the persons who've put together this proposal.
Correct.
What is the consequences then to the fact that something is a sale? There must be consequences to that fact, or else they wouldn't have had to accept a certain kind of transaction from the overall definition of being a sale.
Sales tax.
Sales tax.
And that is what CA engaged in. They paid sales tax. They sent 1099s to individuals who engaged in that as well. The difference between a patient-to-patient sale and a caregiver-to-patient transfer, if you will, is the caregiver is receiving compensation for costs that would otherwise not be subject to sales tax. A patient-to-patient sale would be subject to sales tax, which is exactly why CA paid sales tax.
Does the word sales tax appear anywhere else in the statute?
The word sales tax does not appear in the statute.
This is the implicit way by which the framers of this act are intending to communicate some of the fiscal consequences to marijuana.
Well, if, for example, a caregiver were to sell marijuana to a patient, again, that would be a sale, and there would have to be sales tax for that. And there would also have to be, it would potentially be income that a person would have to claim, minus any costs. This explicitly states that any money that the caregiver were to receive from a patient is compensation for costs only.
So there's no affirmative language in the act allowing for a sale. There is this indirect language indicating that certain kinds of transactions do not constitute sales, and yet somehow we're expected to understand that this is all directed toward the sales tax consequences of transferring and dealing with marijuana.
I understand that you are skeptical, and I expected nothing else coming into the court today. I recognize that...
Are we reasonably skeptical or not?
Well, I certainly, don't want to say anything that may anger anyone, but I understand your skepticism. And when you start out and say our request for relief is that you hold that patient-to-patient sales are protected under the Michigan Medical Marijuana Act, I expected 7 people to ask a lot of questions about that. It takes a long time, at least it did for me, to really wrap my head around it. But when you go back to the language of the Public Health Code, which does not have a prohibition on sale, and when you look at the Michigan Medical Marijuana Act that explicitly protects what is prohibited by the protects what is prohibited by the Public Health Code, that's the starting point.
But Ms. Chartier, you read to me a dictionary definition of transfer, which included the word sale, did you not?
Yes.
Isn't that a problem?
I don't believe so, because the Michigan Medical Marijuana Act protects the transfer. If a person cannot have a sale without either having a delivery or a possession, those are the 2 prohibitions in the Public Health Code that are explicitly protected under the Michigan Medical Marijuana Act. That's not coincidental language, that is specific language. And the other provisions that talk about compensation for costs, or that talk about that the sale of marijuana to a person not authorized to use for a medical purpose, those don't negate the medical use protections that are in 4A and 3E. That actually provides further support for the fact that if the drafters wanted to expressly prohibit a sale, they could have done so. They didn't. In 4K, they could have said the sale of medical marijuana to anyone is prohibited, and you lose not just your card, but you have an additional 2-year penalty, as well as the Public Health Code's distribution penalty. It didn't do that. In the cost section, the drafters could have said that no one is allowed to receive costs, or excuse me, no one is allowed to receive compensation that is not otherwise cost. It didn't do that. This court cannot read in language to the MMA. It has to go explicitly by the language of the MMA, which protects transfer and delivery between registered qualifying patients. If the prosecutor wants to go after a patient for transferring his or her marijuana to another sick individual, they can. But it's not this court, with respect's role, to start doing the government's job for them. Patients are protected when they are transferring to another sick individual.
But it is our role, again, to faithfully read the law that's given to us and try to let the chips fall where they may. As I read the Act, I mean, there seem to be 2 classifications that are the focus of the Act. One, of course, are qualifying patients, and the other, of course, is primary caregivers. I understand the business model that we're talking about in this case, and I understand how it might naturally evolve in the free market, but I just don't see anything in this Act that refers to this kind of entity there. Isn't the absence of that kind of entity telling as to what the architects of this law were intending to achieve here?
I don't believe so. When voters went in November 2008 to vote on this law, most people were very well educated and read the law. It allowed patients to acquire, to transfer, to deliver, to possess, and again, all of the other 9 protections. People knew that a patient did not need to have a caregiver. The caregiver and patient model is only one model. A caregiver doesn't need to be a patient. So a person with no illness whatsoever can possess the marijuana and grow the plants in a husband and wife situation.
But wouldn't you think there'd be somewhere a definition or a reference to a 3rd category, persons or individuals authorized to act by qualifying patients and caregivers? That's what the business is essentially, that's the category it essentially falls into, isn't it?
CA facilitated the transfer of medical marijuana from one patient to another. I don't think that the drafters included that because no one believed that a business model like CA's would ever really be challenged. This is a transfer from one person with immunity to another person with immunity. It's not a transfer to someone with no immunity from arrest, prosecution, or penalty. It's one sick person to another. And I believe that voters, when they went and 63% said yes, recognized that sick people would need to acquire their medical marijuana from somewhere. If the government's position is the one that you were to ultimately agree with, then a patient could never acquire the marijuana from somewhere. That the person who was giving the marijuana to the person to start to grow the plants or to start using the medicine would always be committing a crime. The acquisition would never be able to occur. And given that that's explicit in the medical use definition, I don't think the drafters included it because they included for protections what is explicitly prohibited in the public health code.
Thank you.
Thank you very much.
Good morning, Your Honors. May it please the Court. I'm Rissa Scully, prosecuting attorney for the County of Isabella, appearing this morning on behalf of the people of the state of Michigan. And I'd like to remind the Court or inform the Court that I'm splitting my time with the Solicitor General, 15 minutes, 15 minutes.
You have to manage your own time.
Okay. Thank you. The Michigan Medical Marijuana Act, which I will refer from here on out as the Act, it does not authorize patient-to-patient sales or transfers of medical marijuana. The Court of Appeals in this particular case found that the defendants were engaging in the sale of marijuana, and as such, that their operation or their club was not in accordance with the provisions of the Act. However, the Court of Appeals did not address uncompensated transfers between patients. And so I'm here today asking this Court to not only affirm the decision of the Court of Appeals finding that the defendants were engaged in the sale of marijuana and that is prohibited, but I'm also asking this Court to render an opinion holding that the Act does not allow for uncompensated patient-to-patient transfers, to make a finding that those kinds of transfers are not in accordance with the Act. The Act clearly and specifically delineates two methods in which a qualified patient may obtain their marijuana. They may grow it themselves, or they may designate a caregiver to grow it for them. The Act provides that when a qualifying patient or his registered primary caregiver are acting in accordance with the Act, they are afforded certain protections under the Act when engaged in the medical use of marijuana. These provisions make it clear that the one-word transfer found in the the definition of medical use cannot be read as usurping every other section drafted and approved by the voters. The defendants focus on the word transfer, and the definition of medical use ignores the statutory framework that creates the registration process and the special relationship between patient and caregiver. The Act operates under the framework established by the Public Health Code. The Public Health Code provides that it's illegal to possess, deliver, or use marijuana. And the Act, the Michigan Medical Marijuana Act, did not legalize the possession, use, or delivery of marijuana. Instead, it sets forth very limited circumstances in which people who are engaged in the use of medical marijuana may avoid penalty or criminal liability. This court in Kalanick/King expressly stated that the medical use of marijuana is allowed under state law to the extent that it is carried out in accordance with the provisions of this Act. And subsections 4A and B contain similar language regarding patients and caregivers. A refers to patients, B refers to caregivers. So to be protected under the Act, the use, possession, transfer, or delivery of marijuana must be authorized by the provisions of the Act. As I indicated, the Act sets forth two specific methods for a patient to be able to have his marijuana, grow it himself or designate a caregiver to grow it for him. There is no provision in the Act allowing one patient to assist or facilitate another patient's medical use. If there were an intention to create a patient-to-patient transfer scheme, the statute would say so. The statute would say a patient may obtain his medical marijuana by growing it himself, by designating a caregiver to grow it for him, or by obtaining it from any other patient. There is no such language in the statute, and what is not expressly allowed is prohibited. The Act does not provide that a patient may obtain his marijuana from another patient, and the court shouldn't be reading that verbiage into the statute. Only patients or their caregivers, if they choose to have a caregiver, may possess marijuana for their patient's medical use. Acts outside of this recognized and regulated patient-caregiver relationship are not covered by the Act and are subject to penalty and prosecution. Failure to confine the protections of the Act to those without the established connected relationship under the Act, would create a free-for-all for the exchange of medical marijuana. Other states have statutes that provide for dispensary or compassion center type facilities, and those were in existence when Michigan, the initiative came down. Michigan chose not to include such kind of language in this statute, and it should not be read into the statute. And some may say that the Michigan Medical Marijuana Act is not the most artfully written law. That may be true, may not be true. But one constant that exists throughout this entire statute is the references to the patient-caregiver relationship.
Ms. Scully, what you refer to as a free-for-all, some people refer to a marketplace. And how do you respond to Ms. Chartier's analysis that unless we have some kind of marketplace, the access to medicinal marijuana that's been authorized by this statute really won't be given effect? It won't become effective. People will just not have the kind of practical access that the statute seems to contemplate.
I'm not here to solve that problem, and I don't believe the court is here to solve that problem. What the statute provides for are two very specific ways as to how a patient may obtain their marijuana. If what is in place currently isn't sufficient for those who don't have enough access, then the statute needs to be amended, but it's not for me to provide a solution to that.
What you're suggesting is this is a closed system.
I don't suggest that, but what I do suggest is that
Well, you've described only two ways to acquire medical marijuana: grow the plants, or have somebody who is authorized, the caregiver, to grow them for you. So that's a closed system. There's a lot of marijuana out here that is not grown by a caregiver or a patient. But that is not, as I understand your argument, that is not available to the patients.
it is not, because the statute does not provide for that.
Why would the Medical Marijuana Act specifically prohibit sales by patients to non-patients and non-caregivers under K of the statute, but remain silent as to the prohibition on patient-to-patient sales?
This is one area that I disagree with the appellant. The Public Health Code absolutely prohibits the sale of marijuana. To say otherwise is just disingenuous, and please tell that to the hundreds of inmates that have been convicted of the sale of controlled substances or marijuana that are in our jails and our prisons. You cannot have a delivery or sale of marijuana or other controlled substances without the delivery. It goes without being said. And to argue to this court that the Public Health Code does not prohibit the sale of controlled substances because the word sale is not expressly outlined in the statute.
Wasn't that because you can't deliver it? I mean, in looking at the health code, you can't manufacture, create, or deliver with the intent to manufacture a controlled substance.
Correct.
So deliver subsumes within it a transfer for a price, right?
Yes.
So it doesn't by name or explicitly preclude sales because deliver is sufficient. Whatever reason you deliver for profit or anything else, that's forbidden.
You're right. Of course, a sale necessarily has to include a delivery, but there's also the statute of delivery of marijuana without remuneration, where a friend shares marijuana with another friend, and
But that's a delivery without profit.
Yes, of course. That's prohibited by the Public Health Code.
Yes. And doesn't the MMA recognize the transfer of marijuana as an exempted activity so long as it's done for the purposes allowed under the Act?
The defendant's argument would be that the word transfer must necessarily mean patient-to-patient transfer. And I think that there is a very much more plausible explanation for what transfer means in the context of this entire statute. Transfer can mean transfer of plants from a patient to a caregiver. And a scenario I would like to give is if a patient possesses his own plants and at some point later becomes infirm or otherwise unable to care for his plants, he may want to go to the state and designate a caregiver to take care of his plants and cultivate them for him, thereby transferring plants to his caregiver. I think that kind of scenario, which is definitely a transfer, is much more in line with the intention behind the Act.
There are lots of things that you can do to transfer. I guess you'd like to limit it to the transfer of plants, but I don't see that as necessarily the limitation of the full contemplation of what transfer in this context means.
Transfer is one of 9 terms used in the definition of medical use.
Let's focus on transfer.
Yes.
What about patient-to-patient transfer?
There's no verbiage in the statute that indicates that that's the intention of the drafters of that.
I'm just looking at this.
Yes.
That's how, I don't know what was in the intent of the ratifiers of this initiative. All I know is what they approved and what the legislature was permitted to do around the periphery. And what they said is that the transfer of medical marijuana is an accepted activity protected by the Act, right?
My point of view is that it would be acceptable for a patient to transfer his plants to a caregiver. But because my interpretation, I believe, is in line with all of the provisions of the Act that reference
Well,
the
why don't
specialized...
you focus me on where transfer is otherwise limited by the language of the Act?
It's not specifically, but when you look at the Act as a whole, with all of the various references to the specialized
Well, by
caregiver-patient
implication.
relationship, and there's no other verbiage regarding patient-to-patient, I think it makes much more sense that transfer, as used in the...
What's the language you're relying on most to limit transfer?
all the various provisions that talk about the relationship...
Start
and the,
with the best.
let me pull up the statute. Section 4.
Got it? Which
where-
part?
Sections 4A and B, that talk about the patients and the caregivers.
They're parallel provisions, right?
Yes, sir. And the requirements that if a patient chooses to have a caregiver, the various requirements and necessities that a caregiver must have in order to be that person's primary caregiver. Also, the presumption in Section D.
Let me understand. What
Yes.
you're arguing is Section 4 creates whatever methodology for using and moving marijuana around, they are limited to essentially either the patient's use and cultivation of his own marijuana crop, or the relationship between the patient and the caregiver.
Yes,
That's it.
that's what the statute provides for. 2 methods.
You said the patient can transfer the marijuana to the caregiver?
I think there are certain scenarios where that may
Does that
be
say that in
plausible.
the statute?
It does not. But my interpretation is the word transfer is used in the medical use definition. If in that scenario keeps in line with the intent of the statute to have the specialized connected relationship between patient and caregiver, whereby jumping to the conclusion that transfer, the definition of transfer means patient-to-patient transfers, does not. Because nowhere else in the statute is there any reference that patients may transfer to
So
other
in
patients.
some instances where it's silent, you can imply, but in other instances, you can't.
No, I wouldn't agree with that.
Well, I'm not sure I fully understand your argument either. I thought your argument was whatever the range of permissible activities with medical marijuana, it has to either be the patient's own cultivation and use or the cultivation and use permitted by another person for that patient's behalf, namely the caregiver.
Right.
No other, outside of those two relationships, nothing else is permitted, is what you're arguing.
Yes.
Is that, I mean, you infer that directly from Section 4,
Yes.
because nothing else is explicitly permitted in terms of exemption from criminal sanction.
Yes.
Do you agree that even the Court of Appeals probably wouldn't accept your argument, given their focus on the absence of the word sale?
I'm not sure how to answer that, Your Honor. A large focus of the Court of Appeals opinion, and I don't know if they took the easy way out, but they basically found that because the word sale wasn't contained in the medical use definition, that, of course, it's prohibited by law. But I think we're digging in deeper, and we have to dissect further than what the Court of Appeals went.
So you think an interpretation of transfer, meaning transfer, can't hold water under this statute?
It is what it is.
Well, that's kind of the substance of my question, too, isn't it? Isn't it what it is?
Transfer includes sale, right?
Pardon, Your Honor?
Transfer includes sale.
Oh, sure, it could.
The common definition, I mean, it's an ordinary word.
Yeah.
Well, my argument is simply whether it includes sales or not, and of course, that's part of the issue in this case. Transfer would seem to include transfer.
I agree.
Ms. Scully,
Could I just take one more question and then cede the rest of my time to the Solicitor General?
We'll see.
Ms. Scully, what was wrong with Ms. Chartier's construction of medical use, the way that she defined the term to include any exchange, if you will, as long as the debilitating medical condition of the patient could be tied in? So one could exchange, one could give away one's excess of marijuana, as long as it could be argued that that alleviated someone else's condition. What was wrong with that construct?
She conceded that it had to be the seller's condition.
Yes, the seller's condition. What was wrong with that construct?
What's wrong with it is because that is focusing on one word, transfer, in the definitional section of medical use, and creating these huge exceptions that swallows up all the other provisions of the Act. If the electorate had intended for patients to be able to transfer to other patients, it would explicitly indicate so in the statute.
Maybe they did, when they put transfer in there. Do you want to let...
I don't agree. Thank you.
Solicitor?
Good morning, Your Honors. John Bursch on behalf of the Attorney General and in support of the people. Mr. Chief Justice, and may it please the Court, I'm going to go right to the heart of the discussion this morning, which is patient-to-patient transfers, and they are absolutely prohibited. And the reason are the 5 words in Section 4A that Justice Markman highlighted, in accordance with this Act. Section 4A is not the be-all and the end-all for understanding transfers. There are 4 provisions that apply specifically in this Act to patient-to-patient transfers. They are 6A6, 6E6, 4D, and 4I, and I will briefly walk through each one of those one by one. Section 6A6 says that a qualifying patient seeking registry has to choose whether it's the patient or the caregiver who will be allowed to possess the plants for marijuana. As Justice Markman pointed out, if there was a third choice, another patient, it would be designated in the Act. What this creates is a one-to-one relationship, or if you have a caregiver, a hub and spokes relationship, where you've got a caregiver and up to 5 connected patients where the marijuana can be transferred and nowhere else. That fact is confirmed in Section 6E6, which says that when the department issues a card, the card itself has to show whether the primary caregiver or the qualifying patient will be allowed under state law to possess the marijuana plants for and there's that article again, qualifying patient's medical use. So again, the statute implies a one-to-one relationship and no one else. So now we flip back to a provision that you have discussed, and that is 4D. And I believe that Ms. Chartier's concession on this point is dispositive. 4D, again, in accordance with the Act, informs what the medical use of marijuana in Section 4A means. And D2 says specifically that it has to be for the purpose of alleviating there's the article again, qualifying patient's debilitating medical condition. And as Chief Justice Young very wisely pointed out, we're not talking about the pecuniary gain of another patient. We're not talking about their self-satisfaction for helping another patient. This actually has to help, the medical use has to help the patient's use. You put all those together, and there is no conclusion from the statutory structure other than that patient-to-patient transfers are prohibited.
Isn't your argument even stronger when you look at 4D1, which establishes the presumption, and it relates to the qualifying patient or primary caregiver, And then 4D2, rebutting the presumption, only relates to the qualifying patients.
You are exactly right, Justice.
Because it excludes the caregiver.
That's right.
So the caregiver can make the transfer,
Exactly.
but not the qualifying patient.
Correct, and that's consistent with the structure and language of 4A and 4B, because if you go back to 4B, it says that the primary caregiver may engage in the medical use, or help someone with the medical use, to whom he or she is connected through the registration process. So again, it's locking down this one-to-one connection. The last provision I would reference is then 4I, which refers to a person may assist a registered qualifying patient with using or administering marijuana. So now finally, we have, in Justice Markman's words, the third category of persons. There could be someone else besides there's the article again, qualifying patient and the primary caregiver, who could do something with respect to a registered patient. But here, it's not medical use. It doesn't include the universe of 9 terms. It only includes 2. You can help them use it, and you can help them administer it. You can't transfer it to them. You can't deliver it to them. You can't do anything else. So if you have someone with a legitimate medical condition, and they're unable to administer the marijuana themselves, their spouse could assist them, but their spouse could not obtain and provide to them the plants. It has to come from the patient themselves or from the primary caregiver. Now, Chief Justice Young asks, well, where do you get the plants in the first instance? And there's 100,000 people, actually 112,000 people, who are currently registered right now. It is a closed system, but if you need plants and you want to get them, all you have to do is designate someone to be your primary caregiver, and they can transfer the plants to you. In fact, if you designate them first, and they give you plants, and then you undesignate them, now you're free to grow plants up to 12 as long as you want and for whatever medical purpose that you need. So there really isn't an issue about how to get the plants. The only issue is who do they come from? They've got to be yours or they've got to be your caregivers. So now you move to the question of compensation. Now that we know there's only one transaction where delivery or transfer can take place, and compensation is addressed specifically in Section 4E. And unsurprisingly, it addresses that one-to-one relationship we've been talking about. A registered primary caregiver may receive compensation for cost only. This is not a profit-making enterprise. It is only for cost associated with assisting a registered qualifying patient. As you would expect, caregivers help their 5 registered patients. So you put those two things together, no transfers outside of the caregiver-patient relationship, and no money exchanges other than costs through that very narrow relationship. And what you get is that there is no exchange of marijuana for financial means of any kind, even for cost, except in this very limited circumstance.
You agree that the Court of Appeals erred to the extent that it hung its hat on transfer as excluding the concept of transfer with a sale?
I do not think that was the most persuasive way to approach this problem.
How artfully stated.
I think all you have to do is follow the structure of the Act as we've just laid it out, and you can reach both those things. Unless you have further questions on those 2 points, I actually have 2 other subsidiary issues that I would like to address.
Can I ask you just one more very quick
Yes,
question,
Justice
Mr. Bursch? Do you think that the lawfulness of gratuitous or uncompensated transfers is in fact at issue in this case?
I do, because I think that this operation included not only paid-for transactions, but potentially uncompensated transactions. And
You're not talking
you're
about quid pro quo transactions. You're talking about genuinely gratuitous and
someone walks in and
uncompensated.
they're handed a joint. I think all that kind of activity happens at a business, if you want to call it that, like this. And again, there are over 112,000 people who are registered under this act. It would help all of them, and frankly, all of the prosecutors and law enforcement officials to know what is permitted and what is
But
prohibited.
wasn't there consideration attached to most of those transactions?
I believe most, but I think it's fully within the scope of this case and your interpretation of the Act, just as you did in Kolenik and King with that very helpful appendix at the end to say this is what the Act means. I think number 1 should be no patient-to-patient transfers in any circumstances. Number 2 should be no compensation for the caregiver except for actual cost. So number 3 and 4 in the McQueen appendix will be the next 2 points that I address. The first is that no caregiver can transfer to another caregiver. And really the logic for that is exactly what we've talked about. There is no provision in this act that contemplates caregiver-to-caregiver transactions. And because under the Public Health Code, any transfers are prohibited unless otherwise allowed, the Act's silence with respect to that particular transfer means that it is prohibited and illegal. And the last point that I would ask you to put in the appendix at the end is that there is no caregiver reimbursement except from registry-connected payments. And here you have to go back to 4B to figure out what this means. And really, this is an additional reason why you can assume that only a connected caregiver and patient can exchange marijuana. You have to ask yourself, for what transaction can a caregiver be compensated for cost? Not for profit or anything else, but actually for hard cost. And to determine that, you have to look and see, well, what transaction can they engage in? Well, they can engage in assisting a qualifying patient to whom he or she is connected through the department's registration process. So that is the beginning and the end of the discussion about who a caregiver can give marijuana to and also for what they can be compensated.
What were the 4 points that you said?
The 4 points, yes. Number 1, you may not have a patient-to-patient transfer of any kind. Number 2, a primary caregiver who is connected through the registry to a patient may receive only reimbursement for cost, no profit. That's specifically in 4D. Number 3, caregivers cannot transfer marijuana to other caregivers. It's not expressly allowed in the statute, therefore it's prohibited by the Public Health Code. And lastly, there is no caregiver reimbursement except for their registry-connected patients. And again, that's 4D and 4B working in tandem. And I would be delighted to address any other questions the court may have. Seeing none, I will cede the remainder of my time. Thank you so much.
To whom?
To opposing counsel.
Well, that's
I'm not giving them my time. I'm ceding my time to the court. but I'm happy to let them.
She has no time. I was going to say that was very generous.
Yes, no, I cede my time to the court.
You certainly do. Thank you. The case is submitted.
This was really excellent argument from both sides.
I felt the
Very,
same.
very helpful.